afternoon. We are going to get started. Um, Again, good afternoon and welcome to the O'Donnell Consent Decree public meeting. My name is Dr. Natasha Willis, and I am the Program Compliance Manager with the Justice Innovation Team at the Office of County Administration. For those of you who may be attending a public meeting for the first time, following a class action lawsuit against Harris County claiming the misdemeanor bail system was unconstitutional, a settlement agreement was reached known as the O'Donnell Consent Decree. The consent decree represents the first federal court-supervised remedy governing bail. The mandate requires oversight and accountability of Harris County and all parties involved. All parties recognize that the input and involvement of Harris County residents are essential to meaningful and lasting reform, which will be effective for ongoing system monitoring. As a result, we hold these public consent decree meetings. To read the consent decree, annual reports, or other related O'Donnell information, please visit oca.harriscountytx.gov. We are currently in year 6 of our 7-year consent decree, with this being the second public meeting of the year. Here today to provide an update on the consent decree implementation are Independent Court Monitor Professor Brandon Garrett and Deputy Monitor Sandra Gira Thompson. With them is the Honorable Judge Erica Ramirez, representing the County Criminal Courts at Law, Attorney Rachel Frazier with the Harris County County Attorney's Office. And here soon, we will have Major Matthew Ferguson with the Harris County Sheriff's Office. After the updates from the monitors and parties, we will open the floor for public comments and questions. With that, I turn the meeting over to Professor Garrett. Yep.
Yeah, thank you all for being with us here downtown and hearing the latest in our work. Sandy and I and our team have been honored to serve as monitors in the O'Donnell consent decree since March 2020. So yes, we are going on almost 6 years now of our 7-year term. The consent decree doesn't have a second-year term, but we do, and first, I wanted to give a brief update on our work looking at data, which we're very grateful for the ongoing and hard work by the data team at the county and also at the Office of Court Management. So we get data from the courts as well as some other data. There's been a lot of work over the years to merge it well. And we've reported to you all every 6 months at these meetings what the basic composition and outcomes are in the misdemeanor cases in Harris County. In general, we've described for years now that the misdemeanor system has shrunk. There are fewer people charged with misdemeanors each year. Before this consent decree, it was around 50,000 cases a year. Now it's more like 41,000, 42,000 cases a year. What we've also seen very consistent over time is that the number of people who are arrested repeatedly, has gone down as the number of cases have also gone down. The rate at which people get charged again with a misdemeanor, we talk in our reports about how many people get charged with a new offense, whether it's a misdemeanor or a felony, within 1 year. That's stayed the same basically. 21% of the time, 22% of the time, people get recharged with a new offense. So that's all been very good news from a public safety perspective, that we don't see more people cycling in and out of the system. We have data from the first half of 2025 that our team was looking at and collating before this meeting. The data looks like nearly identical to the data from the first half of 2024. The one change, though, and we talked about this at the last meeting, which is we've just seen steady improved numbers every time we look, has been and the judge will talk about this too, the number of cases that get resolved earlier in the courts. And the county was struggling with the after effects of the court closures during the hurricane when the pandemic hit, and was also not good for getting things done in person in courtrooms. And so every year for the past 3 years or so, we've seen steady increase in the numbers of cases resolved within 60 days, 180 days, 1 year. And so now we're up to 81% of cases disposed, misdemeanor cases disposed within a year, almost 2/3, like close to 60% within 180 days. And that's really remarkable too. It's obviously important for people to get processed and get their hearing in court. Most of the time, almost all the time, it's not a trial, but it's exchange of information between the parties. But at the same time, no one wants misdemeanor cases to unnecessarily hang over the parties' heads for, many months or many years. And that's not happening. And it's taken a lot of hard work to do that, which the judge can pat herself and her colleagues on the back for what they have done. But 6 months later, we're seeing even more good results in the aggregate in terms of cases being moved to whatever the appropriate resolution is faster. In general, we've seen some changes to the composition of what kinds of misdemeanor cases we see in Harris County. In general, although there are fewer cases, there's somewhat more assault and weapons charges, less trespass. And so there are fewer cases, but there are comparatively some more of the more serious cases. So that may reflect some prioritizing, which is not a bad thing. Although the share of cases that we call carve-outs, because they're the cases where the person goes to a bail hearing, they're not entitled to a general order bond for a prompt release. The share of those was a little lower actually last year than the year before. So fewer of the sort of the comparatively most serious misdemeanors. We've seen a steady increase on the number of people who are not carve-outs who receive a general order bond and released fairly promptly from the jail. We also saw a small decline in the rate in the last year of people who are designated for bond failure for willful violation within a year, and that's also good news. So gradual changes, but it's been part of a steady set of really positive outcomes that we're seeing, sort of big picture looking at the data over the past few years. All really positive. Our next report to the federal judge is due on March 1st. We do kind of a full written report, although we share these updates in person and come here to meet with different stakeholders twice a year. We give the judge a full report once a year. And one big new item, which we've talked about here and there, and there's been a lot of hard work by different county stakeholders to share data and information with our colleagues from Texas A&M, Dottie Carmichael and David Shee, who are in the audience here. They've been working for years now, looking at what is the cost picture, what is the budgetary impact of the changes under this consent decree. And some of these changes, it's sort of common sense on their face. They required more resources. For example, people are represented by public defenders, which wasn't routine before the consent decree at bond hearings, and that requires having those lawyers paid and on salary in there. What we've seen in general is that there are increased costs in terms of more cases going forward in court, more court settings, more public defenders, but huge cost savings for the really expensive items, actually, which are the costs of screening people at the jail, booking people at the jail, the kind of intake process, and then detaining people in the jail, and also sentencing related costs. And so those have been really sort of big ticket cost savings for the county that we measure. And there's more sophisticated statistics because we want to look at those changes in costs and see, well, are they explained by differences in the cases that are coming in, or are they just flat out cost savings? And so we will report on those analyses next time around. But there's been a lot of hard work to do that and to get that kind of budgeting information from different county stakeholders. We're just very grateful for all the information sharing and the hard work done to share that, so we could give a more sophisticated and comprehensive report on what money the county has saved through these reforms. Otherwise, from our end, those are the main updates. County Attorney's Office or others may have questions. There has been some motion practice in front of the federal judge between the parties. We're not a party to this case. We report to the judge. And so we're very much on the outside of that. But if you have questions, Rachel Fraser can answer them. Mostly we have, our updates are that we have 6 more months of news and data that looks very much like we had observed before, but even better. And so we're happy to be able to share that with you. Who would like to go next?
Hi, everyone. My name is Erica Ramirez. I serve as judge of Harris County Criminal Court at Law Number 8. It's one of our 16 misdemeanor courts, and I serve as the presiding judge of the county criminal courts at law. Thank y'all for being here. You're taking time out of your day to hear about this work, and it's important. We appreciate you being interested in it. I want to thank the monitors for their continued work in documenting our compliance and our progress, and our justice partners. You know, I see the clerk's office, I see MAC attorneys. It matters. We're a team, and we do it all together, and I'm very grateful for y'all. Y'all have worked close system. We know that access to timely justice is imperative, especially when a person's liberty is at stake. Over the past few years, we've drastically cut our misdemeanor case backlog. We're focusing on reducing the numbers of active cases pending. We've cut the active average case pending by 2/3. We had about 3,000, and now it's about average 940 per court. That's a huge, huge improvement, and we're very proud of that. The Harris County Criminal Courts at Law continue to be committed to ensuring safe and effective bail reform. Misdemeanor bail reform is designed to level the socioeconomic playing field. It ensures that no one remains in jail just because they cannot afford to pay it. It's not meant to be a tool of oppression. It's supposed to be a way to maintain public safety and ensure that defendants who are presumed innocent under our system return to court. Instead of focusing on the ability to pay, it instead allows us to focus on the 2 key issues. Is this person a danger to the victim or our community? And what's the likelihood of this person coming back to court? Appropriate bond conditions such as protective orders, pretrial supervision, other conditions are also helped and used to mitigate potential risks, with the ultimate goal of being set to not have effective conditions in place. That concludes our update. Thank you again for taking time, again to our justice partners, for everyone attending today.
Awesome. Good morning. My name is Rachel Fraser. I'm an assistant county attorney. I have to first share the judges' thanks to everybody, everybody who's worked so hard, and especially the monitors and Dottie. At the county attorney's office, our role is to continue to support the consent decree and to provide legal advice and assistance as necessary. We want to continue ensuring transparency and justice in the misdemeanor bail system. Thank you.
So I'll just wrap things up. Sandra Guerra Thompson. I'm a professor at the University of Houston Law Center and deputy monitor for the monitor team. And I just want to, say every time we come for these site visits, it's always really inspiring to me because we get a chance to visit with so many community members. I, shout out to our friends at the Texas Organizing Project who are always there, as well as Equal Justice, who came out last night. We had a really successful event last night at Wheeler Avenue Baptist Church. And
We had a much bigger crowd.
Much bigger crowd, actually. Texas Jail Project was there as well. And many, many groups. And we, over the course of these 2 days, we get to sit down with not only community members who work with us throughout the year. So just, in case any of you are not aware, we have representatives who work with and represent a lot of the affected people, like foster kids, people with mental health challenges, people who are unhoused, as well as civil rights advocates, law enforcement representatives, and others. There are so many different parts of our community that are affected. And so when we come to Harris County for these visits, we not only get to talk with the community, but then we get to sit down with all of the different stakeholders. So we're grateful to the Public Defender's Office, the Office of Manager Assigned Counsel, the District Attorney's Office, the Harris County Sheriff's Office, all of the various groups that will sit down with us and help us to better understand the system-wide what's going on and where there are even greater efficiencies that can be gained, and understanding the data that we're seeing, which, as Brandon already mentioned, has been very consistent. One of the things that I'm greatly excited about is that with the bail reform changes that the courts made in 2019, we immediately saw the terrible racial disparity in terms of who was released from the jail without having to pay money. That disparity disappeared, and it has not reappeared. I mean, that rule change of taking money out of the equation for the majority of people in the misdemeanor area made a dramatic impact in terms of greater fairness in Harris County. So we're really proud of to be a part of this and excited to continue this work. So thank you so much.
Okay, thank you so much for that review. We will now begin the question and answer portion of this meeting. We'll start with in-person questions and then take questions from our online audience. For those in person, if you have a question, please come to the podium and state your name and affiliation in the microphone before asking your question. For those online, you can start to list your questions now. Please also include your name and affiliation in the chat for me to read out loud. And please make sure you turn on the microphone, the button right in front of you. Yes.
Good afternoon. I am Dr. Doshi Piper. I serve as the statewide restorative justice coordinator at Texas Organizing Project. Our members have been closely following the implementation of the O'Donnell consent decree and its impact on pretrial justice here in Harris County. Today, myself and several members are here to share some brief comments and questions to deepen community understanding and accountability around the degree outcomes. My question is around jail diversion. Has the O'Donnell team or the Sheriff's Office taken steps to divert people who are general order bond eligible from being booked into the jail altogether? This could further reduce jail population and save county resources.
I mean, there certainly is ability to divert people at the point of arrest. So I think it would have to be the arresting agency that made the choice whether to divert someone at the point of arrest and do basically the equivalent of a sudden release. When we've looked in the past, the numbers have been fairly small.
I know the district attorney's office, and this is a relatively new change, did put some mental health expert prosecutors at the Joint Processing Center to try to intercept law enforcement when they're bringing folks in who really ought to be diverted to other more therapeutic settings. And I know that has had some effect. Now, to do it for all GOB eligible people, we don't have, I mean, the thought is that there has to be some level of processing done when you have a GOB case, right? It's still an arrest on a relatively low-level misdemeanor charge, but it's still an arrest for a low-level crime. So, those folks would have to go to the processing center to have that process handled. I'm not sure that we could, I suppose it's possible to streamline it further, but I don't know, it's sort of beyond our
Thank you.
capacity? Yeah, it's a good question, though. Thank you.
And I think to sort of to do booking and to do field citation and release would take more resources for some of the law enforcement agencies to be able to. And that was one of the concerns that motivated create the Joint Processing Center, was to put the processing resources in one place. But it certainly, there are categories of offenses which are eligible for a cite and release under Texas law. And
Yes.
it's certainly a possibility if the will and the resources were there.
Thank you.
Yeah, and just the only other thing I will say about that, right, is that there is a 48-hour time limit for how long people could be held without any kind of process happening. And the sheriff's office, we do keep track of how long people are in, and ideally people who are GOB eligible, we'd like to see the amount of time it takes to get processed reduced. So that's something they're very aware of.
Okay, thank you.
Good afternoon. How everyone doing? Christopher Jenkins, CLT supporter and member at Texas Organizing Project on the Right to Justice Committee. And I want to thank the county for establishing the community working group. So my question is, how has input from the CWG contributed to the implementation and improvement of the O'Donnell consent decree? And are recommendations being documented and acted upon? And I also have a follow-up question. Beyond the community working group, how is the monitoring team ensuring that people with lived experience, those directly impacted by the system, have a seat at the table in evaluating and shaping ongoing implementation?
I guess one clarification is the community working group was something that we convene to advise us as monitors to get input and information from the community. And so it wasn't something the county created, right? The community working group is a working group to advise us in our role, ourselves, providing input and updates to the parties and ultimately to the federal judge. And by the way, so anyone in Harris County can reach out to us. We have gotten input from members of the community, sometimes anonymous. There's a forum on our website, and sometimes people have highlighted cases to us which they had questions about or had concerns about. And so anyone can raise questions or concerns with us anonymously using our website, or not anonymously if they just want to shoot us emails. And our contact information is on our monitor website, but also, I teach at Duke Law School. I'm the out-of-stater. Sandy's at the Houston Law Center. Our emails are on our, university websites. So anyone can raise concerns, whether it's specific about a case or something they've been seeing. And we've gotten both kinds of concerns from members of the community. Community work group, we have discussed in our reports, kind of big picture observations among our community work group. Sandy has been doing interviews and sort of sharing just sort of whole perspectives from stakeholders. But they've also provided a lot of insight in terms of like how are these changes to the misdemeanor system playing out in the communities that they see. And so they've just been a sounding board every step of the way.
Yeah, and we have included people with lived experience in the group as well. And it's really helpful because, for example, we had one member early on who was very concerned about the kind of training that people in the jail would get and whether it included trauma-informed training. So that they would better understand the population of people that they're working with. And so getting that feedback is super helpful for us because as I said, we seem to be at the nucleus of a lot of things. So we're interacting with a lot of different parties, but we were able to communicate that back to the sheriff's office and back to other agencies to talk about, hey, we really think this is not a bad suggestion. You ought to think about having some trauma-informed training for staffers that are dealing directly with people who are, going into the JPC.
So is there a process, or could there be more transparency in how the community can get more engaged in this process? Because I believe the last time I was at a meeting about the decree was back in March over at the Harris County Department of Education.
Mm-hmm.
So is there a process or a way that we could start to have more transparency with community organizers in the community to get more involved.
Yeah, I would just reach out to us. I mean, so we have our official meetings twice a year. So we had one in March and we're having one now. We'll have two more next year. And, but there's no reason we can't meet between those meetings. And we've sometimes met, it's tended to be more when the folks at the community working group say, like, could we have an extra update? Or there's a reason why we or they want to get together in between those meetings. I mean, it's nicer to get together in person, not be on the phone or on Zoom. So we tend to try to gather during these meetings twice a year. But if there are other things you want to share, let's just talk.
Why don't we talk offline later and
Yeah.
figure
Okay,
it out?
that's fine.
Because I'd love to hear what you have in mind.
Okay, thank you.
Thank
All right.
you.
Good afternoon.
Yeah.
My name is Cecilia Fontenot with the Texas Organizing Project. My question is around addressing structural barriers. What additional interventions is the team considering to address barriers like transportation, childcare, and housing that impact a person's ability to appear in court? These are real challenges that impact working families every day.
Yeah, so we actually, I think there was a bigger update last time and we talked more about the myharriscounty.com and the kind of exit folders that people are receiving with transportation vouchers. Do you want to talk more about it or? Okay.
So
Correct, but so
I can give a little update,
Yeah.
Brendan. So we have part of the consent decree required that we do a study to understand why individuals don't appear in court. And so after that study, we partner with the county attorney's office. I know Seth is very versed in that, but we've been working closely together and there was a plan. And so part of that plan is we are partnering with the Harris Center for CARP. It's Community Assistant Referral Program. And so they are actually working on, so they were already kind of providing some resources, such as maybe helping individuals, find childcare, different things. Part of this non-appearance plan, which is also on our website and it's public to share, is to help them with transportation. So that is something that the consent decree required that we spend $850,000 a year to be able to help with assistance. So in addition to those, we also have the myharriscountykcase.com website. We're working on putting kiosk into the criminal justice center so that individuals, when they show up to that building, a lot of times, like say it's your first court appearance, right? You're not sure where to go. But the Harris Center, that CARP team, they actually work and have those folders. They're providing them information. We're partnering with pretrial for text reminders. So there are a lot of things that are in place. We're going to be creating some educational videos as well soon that will be for public. But that myharriscountykcase.com is great for families, those advocates who are assisting individuals, where they're now able to go on there easily. You don't have to create an account. But we do have some things in place, and that is a part. So we're hoping by March to have a real update on the transportation and even some data as well to be able to show how those resources are actually helping. That we're hoping, it seems like, to increase the appearance of individuals.
An additional question. If a person does not show up for court, do you send out any type of notification asking them, why don't you show up?
So that is not something that would be a part of O'Donnell. That would probably be more of a pretrial question, which we can definitely work on finding out for you. I don't know exactly how their court notifications work, but I do know that they work with them. And again, also that CARP team, they are also notifying people. So that's a great question that we will definitely follow up on, and we'll get with your organization on that.
Although in general, one thing that the consent decree also changed is not all court appearances are ones where it's required for the defendant, the person charged, to be there. So some of them are scheduling type matters that the lawyers handle. Some of them, the person is supposed to be there, and if they're not there, they may have, certainly have some explaining to do at another appearance before the judge. So it may be that the judge is the one who's asking the lawyer, like, why is your client not here, or asking the client to provide an explanation. But one change under this consent decree is that it's not always required that someone be in court. And so that's also makes it important to know, like, when's the next date coming up, and is that one that my lawyer needs me there for versus not.
Okay. Thank you.
Hello, Commissioners. My name is Alicia Piper. I'm a top member, and I want to lift up the importance of fair hearings. My question is around bail hearings and legal counsel. Under the O'Donnell consent decree, misdemeanor arrestees are granted an attorney at bail hearings. How has this guarantee of defense counsel impacted case outcomes? And have we seen shorter jail stays or better pretrial compliance as a result?
Yeah, so that's we do think that that's one of the core fairness due process protections. And especially, as lawyers, Sandy and I are always grateful to hear people uplift the importance of having a public defender, so that there's someone to speak on your behalf at a bail hearing. Because while bail hearings, it's not a trial, but people's liberty is at stake. And you had people in the past who were uncounseled, didn't have a lawyer. So what we've seen is that over time, the number of people who spend any time in the jail, but also the length of jail stays have gone sharply down. When people, it's a very small minority of people who are held in the jail, and when they are, it's usually just a few days. It's a very, very small number who are in the jail for, more than a week. We also watch the bail hearings. They're videotaped, and just to get a sense of, like, how are the public defenders advocating? What is the back and forth between the public defender, the prosecutor, and the magistrate? The hearings are longer. They're more, people are actually talking about kind of what are the relevant things that we need to think about to decide what the right outcome is for this person. They're not kind of rubber stamp. I mean, there were some infamous videos from the old days, these 30-second hearings, where people were told not to talk. There was no lawyer, and there kind of wasn't anything to talk about because there was a bail schedule. And so if you were arrested for X, then it was $2,000. If you were arrested for Y, then it was $3,000. There wasn't a decision about, what does due process demand here? Is this person a public safety risk, a flight risk, or not? And so the length of the hearings has changed. The quality has changed. There are certainly always improvements that can be made in terms of, like, the advocacy and the quality of the information. We want to put the best information before our magistrates and our judges. And there are ongoing trainings for lawyers on all sides to improve the standard of practice at bail hearings. But we've been consistently just impressed with just how these hearings have changed.
Thank you.
Good evening. My name is Seneca McQueen Jr., and I'm a resident of Harris County and also a member of Texas Organizing Project. So I have two questions. My first question is around court appearances initiatives. The monitoring reports mention two non-appearance mitigation initiatives: the Community Assistant Referral Program, known as CARP, and court date reminders. Can you explain the difference in their approaches to improving court appearance rates and how successful each has been?
Yeah, thank you. And thank you for all these questions, all of you. So the court appearance program was a little bit of, it was what Natasha was just described, where people are getting, through pretrial, the ability to get electronic notifications on whatever kind of device they prefer. Separately, though, without a notification, you can also just look up, or a family member or a friend can look up when someone's next appearance is on the myharris.com website. So just more convenient ways to get notified about court appearances, or just to look up, what court am I in, which of the 16 courts is it supposed to be, and what's the date, what's the time. And separately, the CARP, the CARP initiative, is providing people more, identifying people who could benefit from resources. And so that was the kind of more one-on-one individualized work that Natasha was talking about, where people can get bus passes, transportation vouchers, referrals relating to childcare, that kind of more hands-on assistance.
Okay, my second question. So it's in regards to, you mentioned that y'all had a 7-year term, but you don't
Yes.
have a 7-year term.
So
I wanna say
the consent decree doesn't have a 7-year term. We were appointed as monitors to a 7-year term.
7 years. Okay, so I've been a part of 2 consent decrees. And once the monitors stop coming and getting information, you get so much information, then you turn it back to the court. You know the process. Once they get so much information, you see them less. And those 2 consent decrees I'm speaking of, you see them less. And then once you begin to see them less, everything go back to change. They no longer be compliant because they have no one this would hold accountability to. So what is the plans for this, the O'Donnell decree, not to end up in that position? And how long term will be monitoring to make sure that they're compliant?
We only know about our 7-year appointment. It would be between the party divisions need to be in place so that all this work is lasting. I mean, ideally, you do want a system where the improvements in the way that cases get handled have staying power, and you don't need someone like Sandy or me having community meetings and reporting on it. Ideally, it works so well that it just works, and that if there are errors or cases that fall between the cracks, there's a way of catching them and remedying the slip ups and so.
Yeah, I would also say that a lot of the goal of the consent decree, and it was really a very well crafted agreement, was to require changes that would be permanent, that would end up being permanent. So I don't see us going back to a place where there's no public defender at a bail hearing. I don't, we're going to have the website of my Harris County case. That's not going to go away. It works too well, to help people know where to go for their court. The amount of money it takes to maintain that is so little compared to the benefit, right? Or things like the electronic notifications to tell people, or the fact that you don't have to go to court for every single setting like you used to. People would have to go every single month practically, right, to court. They don't have to do that anymore. And I don't see us going back because it just becomes part of how things are done. And to change it would create a lot of problems now. So I think a lot of the things that have been implemented will end up being pretty permanent. But that is definitely something that we've had in mind, and that is one of the goals.
Okay, well, thanks for that clarity. Thank you very much.
Good afternoon. My name is Wilfred Young. I'm a member of Texas Law Organizing Project, and also I'm a member I live in Harris County. My question is around improvement around bail hearings. How have bail hearings improved overall under the decree? Are there specific practices or safeguards that have made progress or more transparent or equal?
I guess in general, like I was describing, having a public defender there, having these longer bail hearings where there's more of a discussion of what does public safety demand has been just a remarkable improvement. I will say the area that we've noted in our reports where we really do think that there's room for improvement, where we don't see the defense raising, we don't see the prosecution discussing so much, we don't see magistrates asking questions, has been around, well, what conditions are appropriate for release in the community. And we often see conditions that just on their face seem like they're unlikely to help with the case. In the past, pretrial services had described how you'd have, drug testing ordered in cases that don't involve driving or with drugs or intoxication. We heard about a person who was unhoused having an ankle monitor. Like that didn't seem to make sense on its face. And it just seems like, the consent decree requires, like the Constitution does, that, conditions of release are conditions on someone's liberty, right? They restrict people's liberty. And anytime you restrict people's liberty, you need to be doing that in the way that's least restrictive. You don't want to unnecessarily take people's liberty away. But it's not common, watching the videos of the bail hearings, for there to even be a conversation among the parties about with the magistrate about, well, what are the least restrictive conditions? What conditions are appropriate? I think both the prosecution and the defense are sort of mostly focused on the question: is this going to be a secured bond, which an indigent person is unlikely to be able to pay, or is it going to be a personal bond where the person is going to be released to the community? They're focused on, sort of on or off release or detain, and not on, a lot of cases of people who are released in the community, but there's this question: are these conditions too restrictive? Are they going to make it hard for them to get to work or do their job? Or are these conditions quite necessary to protect the community? And we don't see that's definitely been one of the subjects of the training, to encourage lawyers on both sides to exchange information about that and have more of a conversation about that with the magistrate or later with the judge. And certainly conditions do get revisited in cases. There was a program that got a lot of national attention that had really positive results, where folks at the Kennedy School did a study with several of the judges. I don't remember whether you were one of the participating judges at the time or not, but it was a group of, like 4 or 5 judges participating in a pilot study where there would just be sort of auto recommendations every month saying, like, these are people who've succeeded in all their conditions. So you could reduce the conditions, say take one of the conditions off and see how they do. And then the next month, if they continue to do well, then you could step the conditions down a little more. And they documented, well, what happened in the cases that were stepped down versus the cases that weren't. And they found that over time, it's kind of automatically revisiting the conditions had really positive effects. It took some resources to run that program, and it hasn't come back since. But there are additional proactive things that could be done to think about this question of, well, what are the right conditions that aren't sort of unnecessary expense for the county and that are in fact really important to protect public safety, versus the ones that take away people's liberty unnecessarily. That takes all sides to really do more to advocate on, and that's something we don't see discussion of, with rare exceptions, at the bail hearings.
Okay, thank you.
Good afternoon, and good afternoon, Judge. My name is Mark Ash. I had a concern about a case involving an out-of-county bond. And what happened, the facts of this case are very simple. This client of mine had a warrant for her arrest for a DWI, and it was a to-be warrant, and it was set at 8888888. And she didn't get picked up in Harris County. She got picked up on traffic in Montgomery County. And it was on a Friday afternoon that she got picked up. And I was notified, of course, that she was being held on a bond for a DWI at 8888888, which in my opinion, obviously is very unreasonable. And I told them that there was nothing I could do. Apparently, the magistrate judge in Montgomery County just kept it at that 888 number. And on Monday morning, I approached the judge in county court, which shall remain anonymous, and that judge set the bond at $100. And then I thought, well, that settles the matter. Well, it took another 2 days before Montgomery County would honor that $100 bond. I sent the information to Montgomery County showing that the judge has set the bond, the county judge has set the bond at $100. But they were informing me that that information was not acceptable means of transmission or communication. Apparently, they said it had to be directly transmitted through a fugitive office and through Harris County system. And I just believe that she had spent 5 days in jail. And by the way, her case was dismissed 3 days later because the state realized that the case was old. It was from 2019. So I just thought that it was unnecessarily she spent 5 days in jail. And I'd like to see if there's a way that this situation could be improved, because some people do get picked up on to-be warrants outside of Harris County. And those bonds should not be set so high, especially if they're misdemeanor bonds, like in this case was a DWI first with no priors. So that's why I'm here addressing that issue. I don't know if any of you have know a little bit about that issue, and if it hasn't been addressed before.
We've seen those cases. I mean, the consent decree doesn't speak to those types of situations in particular. My understanding was the 888 code wasn't like a dollar amount for 888,000. It was a code indicating that it's an out-of-county hold,
Well,
right? Is that?
My point being is that 888 code took at its face value, and Montgomery County put that bond on their 8888.
Oh, interesting. So it might be that the out-of-state, Montgomery County misunderstood what the code meant and then treated it as a dollar amount. But it sounds like there were other logistical problems too with the county just not
That
giving.
was the first issue. And then the second issue was it took an extra 2 days for them to be communicated that the $100 bond was set. Monday morning, judge set the bond at $100, and they did not respect that bond and honor that bond until Wednesday morning. So it was a delay of 2 days, unnecessarily so. That's just what I'm bringing up, so that I think that if you all can look into that issue, I would greatly appreciate it, unless you have some questions.
Thank you. That's really helpful. And just to make sure, so that what the county was saying, aside from the bond amount issue, is that they needed communication through some kind of a out-of-state fugitive system, and that the bond order itself wasn't sufficient.
Yeah, it was an out of county. It was a misdemeanor.
Yeah.
And so that 888 code, I think the judges need to look into it, and I would appreciate that. And I appreciate that you are listening to me. Thank you.
Mr. Ash, I actually have an update. So the code's no longer used and hasn't been used for a while. Like you said, it was a 19 case, so that's probably why it wasn't there. But we created a bond exception field so they don't have to use that 888 again. And that's terrible that happened to your.
It just happened recently, and it was from a case that was filed in
19.
2019.
We no longer use the code, yes.
Okay, I was not aware of that. I was not aware it's no longer used, and I appreciate that. Thank you. Thank you all.
Thank you.
Hi, I'm Eleanor Matheson. I'm here as a Harris County resident. So, as we all know, there are over 30,000 defendants out on bonds at any given time in Harris County. How does the county make sure that sufficient resources are allocated to pretrial services to adequately supervise all of those defendants out on bond?
In some ways, that's a question that's kind of, the consent decree didn't call for additional pretrial supervision resources for the most part. It called for resources around court appearance and promoting court appearance. But that's a little different than providing people with supervision, which can restrict liberty, and it can also provide services. But pretrial services didn't sort of receive extra supports. And some of the work in the consent decree that is sort of within our bounds, some of the, with the topic I was talking about in terms of thinking about what conditions really promote public safety. If a condition is time consuming and resource consuming for pretrial services and doesn't promote public safety, then that's money that could be used for something else. And so there are some prioritization, ideally adhering to the due process standard and focusing on the conditions that are the least restrictive should also free up resources for pretrial services to be doing the work to protect public safety and provide the supervision that's valuable versus the supervision that isn't. But to the extent that members of the community like you would like to see pretrial services with different types of supports, that would have to come from the county and from other initiatives.
Okay, thank you.
Okay, thank you so much for the in-person questions. We do have a few online questions. The first question is, what effect, if any, has SB 9 had on the consent decree?
Great. So there's a short answer and a modestly longer answer. So SB 9 is a law that was passed earlier this year that took effect in the beginning of September. And it lists a long list of offenses. which I can't rattle off. In general, it involves felony offenses. So most of the cases that are affected by the new law are felonies, and so not really within the O'Donnell ambit. But some of them are misdemeanors, and our view is that the consent decree as a settlement between all the relevant parties doesn't change, even if Texas law does change, unless the parties modify the consent decree and the judge agrees and the consent decree terms change. And there was a request exactly along those lines by several of the judges this summer to modify the consent decree to reflect the change in Texas law. There is presently, I kind of briefly alluded to it earlier, motion practice before the federal judge, where several judges and also the Attorney General have made motions saying that the consent decree should be modified to reflect this change, SB 9. Until that change happens, the consent decree, so far the consent decree hasn't been changed, and so Rule 9, the consent decree, operate the way they always did. And but that depending on what the judge is convinced of when the parties make their arguments, there could be a change to reflect Texas law or not. We don't know. So since we're not parties, we're not involved in that litigation. Our understanding is that the relevant lawyers will be making arguments before the judge in the months to come, and there will be a schedule for that, and we'll know more at some point. But that'll be something we'll learn about in the future. For now, while felony cases in Harris County are certainly affected by SB 9, and I'm sure some work has been done to figure out how to incorporate those new rules into the practice in the courts, misdemeanor cases, the consent decree and Rule 9 haven't changed.
Thank you so much. The next question is, what offenses are not eligible for either a PR or GOB bond?
Well, so there are no offenses where it's required that you're not allowed to get a GOB. So there's some offenses that are eligible for a GOB bond. Then there's some, not just offenses, but situations where you're not eligible for a GOB bond. For example, it's not the offense, but it's the fact that you committed an offense while you're out on bond. If it's a violation of bond, then you're not eligible for a GOB. And so those cases go to a bail hearing, and then there's a decision made. Is a personal bond or a personal bond with conditions or a secured bond appropriate? And that's what the bail hearing is about, is what is public safety or the concern about flight risk? What does that demand in the situation? But there aren't any categories where it's like required that one impose a secured bond. It's a decision that's made after the parties present evidence to the magistrate.
Okay, next question. So there wants to have some clarification on how much monies are available for transportation costs to appear in court and where do those funds come from. So according to the non-appearance plan, there was $100,000 set aside for CARP to work on those transportation costs. And those funds come from the general funds for Harris County. So Harris County is responsible for that. Next question. Do you do CT specific, it says 1 through 16 statistics about bail hearing decision results? Do you know what that means?
So in terms of what happens at the bail hearings, how often does the magistrate decide upon a personal bond versus a secured bond? Yes, we absolutely see that. And we've talked about that. We've definitely summarized those outcomes in our reports. So yes, and it's public information. One can check on the court's website and look up a case and see what happened in terms of what bond was set.
Okay, thank you. Then there were a few questions just about the non-appearance plan. So again, you can actually find the plan on OCA's website. And we will definitely make sure that at our next public meeting, we have some additional updates for everyone. I think there were a lot of questions about just how much we spent so far, data and results. And so we are working on that. And then lastly, our pretrial director, Natalie, is online, and I think in reference to the last in-person question, just clarifying. So again, pretrial services also receive support for their justice navigators through the non-appearance plan. Again, it's not for pretrial supervision, but she did just want to clarify that. So again, there are monies that have been provided to different programs and support, more for supports and resources, but that did not go towards pretrial supervision. And that was the last online question that we had. If there is nothing else from the group, then that concludes our meeting. And thank you everyone so much for attending. Have a great rest of your day.